All right, guys, this is one of those moments you don't want to miss. From the very start, you can feel the tension building as this defendant walks into court already loaded with the usual sovereign citizen playbook. He starts throwing around titles, claiming authority, and trying to control the narrative before the judge even gets comfortable. But here's the twist. This isn't just any judge. This is a judge who does not tolerate nonsense. Within seconds, the courtroom dynamic shifts completely. The judge makes it crystal clear that this is not a game, not a debate, and definitely not a place for fantasy legal theories. The defendant tries to resist, tries to argue identity, tries to separate himself from the legal name, but it falls flat instantly. And just like that, the tone is set. This isn't going to go the way he thinks it will.
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
Now, this is where things start heating up fast. The defendant insists on representing himself, rejecting legal counsel like he knows better than someone trained in the law. That's always a dangerous move. But here, it's about to get worse. He starts questioning jurisdiction, throwing around buzzwords like admiralty and common law, without actually understanding what they mean. The judge, clearly experienced with this kind of nonsense, shuts it down piece by piece. Every time the defendant tries to twist the conversation, the judge pulls it right back to reality. And when the defendant refuses to follow simple instructions, like sitting down and staying quiet, the judge doesn't hesitate to escalate. You can feel it building, the frustration, the tension, the inevitable clash. Because this isn't just misunderstanding anymore. This is outright refusal to accept how the courtroom works.
Appearances for the people versus Frank Michaud Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not. You have work. So
Yeah,
you're on Friday.
Are you up? Please sit at the desk representing yourself.
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
All right, now we hit the point where consequences start rolling in. The defendant keeps interrupting, keeps pushing, keeps ignoring direct orders, and the judge has had enough. Contempt of court. Just like that, fines start getting issued. And instead of correcting his behavior, the defendant doubles down, acting like objections alone somehow override authority. But that's not how this works. The judge makes it painfully clear. You don't just say, I object, and expect everything to stop. You need legal grounds, structure, logic, none of which the defendant is providing. Meanwhile, the prosecution is ready to move forward. Witnesses are being called, and the case is progressing whether he likes it or not. And through all of this, the judge maintains control with absolute authority. This is no longer a debate. It's a demonstration of how quickly things fall apart when someone refuses to follow basic rules.
The courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here is through the microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, you know, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, you know, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Now here comes one of the most critical moments in the entire hearing. The defendant starts arguing about probable cause, claiming his rights are being violated because he thinks the process isn't being followed correctly. But once again, he's completely misunderstanding what's happening. The judge breaks it down in the simplest way possible, explaining the difference between a probable cause conference and a preliminary exam. It's basic procedure, something any trained attorney would understand instantly. But instead of listening, the defendant keeps arguing, keeps interrupting, keeps trying to force his own version of reality into the courtroom. And this is where it becomes obvious. This isn't about confusion anymore. It's about refusal. He doesn't want to understand. He wants to win. And in a courtroom, that mindset is a guaranteed disaster.
So, with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So, today.
You have a jurisdictional argument you want to make?
Well, I've served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the.
All right. Now things go completely off the rails. The defendant starts bringing up irrelevant arguments, bond claims, affidavits, fee schedules, none of which apply to the situation. The judge shuts it all down immediately, making it clear that none of these tactics have any legal standing here. But instead of adjusting, the defendant keeps pushing, accusing the court, questioning authority, and refusing to give a straight answer to a simple yes or no question. That's when the breaking point hits. The judge demands clarity. Are we proceeding or not? And instead of answering, the defendant tries to argue again. That's it. Contempt. This time, not just a fine, jail time, 30 days. Just like that, everything changes. This isn't theory anymore. This is reality hitting hard and fast.
You ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
this? Is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
you want to see it?
Affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so.
You said you wanted a sworn complaint.
From an injured party. Who have I injured for the record?
The state of Michigan.
How can I
are bringing the charges?
How can I injure the
state?
Sir,
sit down. Sit down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
And just like that, it's over, but the impact sticks as the defendant is taken out, still trying to argue, still refusing to accept what just happened. The courtroom returns to order. The judge even reflects briefly, making it clear this didn't have to go this way. There were opportunities, real chances to handle this properly. But instead, the defendant chose defiance over strategy, ego over logic. And that's the pattern you see over and over again in cases like this. People walk in thinking they've cracked some hidden legal code, only to collide headfirst with reality. Because at the end of the day, the courtroom isn't the internet. It doesn't run on theories, beliefs, or YouTube research. It runs on law. And when you refuse to play by those rules, the outcome is almost always the same.
Appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge. The people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration, with an exception for the OIC.
Right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still